Hello, everyone. Thank you for attending today's webinar, EEO Implications of Dobbs. This webinar is part of Being Resourceful, Thomson Coburn's HR Law webinar series presented by the firm's Labor and Employment Practice. Please visit thomsoncoburn.com for information on next month's program and to sign up for future webinar invitations and alerts. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, but if a fuller answer is needed, or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit and in Missouri for 1.2 hours of general CLE credit. Additionally, this webinar is CLE accredited in New York for 1 hour of experienced and transition credit. This webinar is also approved for 1 hour of SHRM and 1 hour of HRCI credit is pending. We award credit based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we will display a secret word and multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full credit. Again, today we're going to cover the EEO implications of Dobbs versus Jackson Women's Health Organization. My name is Zoe Spector. I'm an associate in Thomson Coburn's Labor and Employment Practice. Myself, along with my colleague, Allyn Lowell, who's counsel in our Labor and Employment Practice, will be presenting on these topics. As you know, our discussion today is on the niche intersection of the lack of a constitutional right to privacy and abortion and implications for employers, particularly in equal employment opportunity or EEO facets of employer obligations. This change in decades-long precedent was set by the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, which was argued at the end of 2021 before the Supreme Court and decided on June 24th, 2022. Although it has been almost a year, this decision has still left everyone with more questions than answers. This is no different for employers, who may be wondering, do I need to make sure my benefit plans provide coverage for out-of-state procedures? Do I need to provide travel benefits for employees seeking an abortion in another state? Does leave to travel for an abortion constitute eligible leave under the FMLA? Am I, as the employer, going to be liable in states where abortions are unlawful if I provide additional leave in my leave policy for employees to use to travel for an abortion, even if I'm unaware that is what the employee is using the leave for? We will broach these questions in our presentation today, though as you will see as a theme throughout the presentation, and as it typically goes with these new landmark decisions, it is not entirely clear. As brief background, the Supreme Court in Dobbs versus Jackson Women's Health Organization reviewed the constitutionality of Mississippi's Gestational Age Act and upheld the Mississippi law, concluding there is no federal constitutional right to an abortion. The Supreme Court decision, which we refer to in shorthand as the Dobbs decision, overturned Roe v. Wade by reversing Roe's finding of a fundamental constitutional right to privacy and abortion. By reversing Roe, the Supreme Court left the regulation of abortion to the states. In the court's own words, the Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. Beyond the straightforward implication that Dobbs holds there is no constitutional right to an abortion, the Dobbs decision sparked a discussion on the possible reconsideration of several other landmark Supreme Court cases, including Griswold, Lawrence, and Obergefell. Justice Thomas explicitly stated in his concurrence that in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. As a very brief background, the Supreme Court in Griswold ruled that married couples had the right to purchase and use contraceptives and not be restricted from purchasing or using said contraceptives. The court in Lawrence invalidated sodomy laws and made it lawful for consenting same-sex adults to engage in intimacy. And Obergefell established the right of same-sex marriage. Although those decisions do still stand today, the Dobbs court more or less put citizens on notice that the analysis used to decide the Dobbs case may one day implicate the precedents set in the Griswold, Lawrence, and Obergefell cases. The possibility that those cases may be at risk of being overturned also presents important questions for employers, similar to those raised in light of the Dobbs decision. Justice Kavanaugh also raised another crucial question in his concurrence regarding the constitutional right to interstate travel and whether states would now be able to restrict travel for an abortion. Justice Kavanaugh stated that some of the other abortion-related legal questions raised by today's decision are not especially difficult. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. Again, that quote came from Justice Kavanaugh's concurrence in the Dobbs decision. Again, these are all questions without clear answers, but that are important for employers to keep in mind and consider when taking any potential action as a result of the Dobbs decision. Though the resolution to these issues is by no means absolute, thinking about all of the various implications, outcomes, risks, and variables of the Dobbs decision will help employers become more informed on the risks of taking any action to change company policy following the Dobbs decision. As abortion no longer enjoys federal constitutional protection, states are free to restrict it civilly and criminally, so long as such strictures are otherwise constitutional. There is no federal protection for abortion, but also there is no criminal liability or punishment for abortions under federal law. During this webinar, we will discuss the current landscape of state abortion laws, including the significance of varying state laws on abortion for employers. We will also discuss the legal challenges and unsettled legal framework of abortion laws in various states. We will also discuss the overarching EEO implications of the Dobbs decision for employers, including the Dobbs implication on the Federal Pregnancy Discrimination Act, the Family Medical Leave Act, the Americans with Disabilities Act, and privacy protections under HIPAA. We will also delve into the potential risks of criminal and civil liability at the state level, along with ERISA and benefit issues. Finally, we will briefly discuss some practical workplace concerns that employers may already be experiencing in the aftermath of the Dobbs ruling, such as employee disputes, political discussions in the workplace, accommodations, and health reporting. We will leave time at the end of our presentation for questions. In the wake of the Dobbs decision, Idaho, South Dakota, Texas, Oklahoma, Missouri, Arkansas, Louisiana, Mississippi, Alabama, Tennessee, Kentucky, and West Virginia have implemented and are enforcing the strictest laws and policies against abortion access and care in the country. In Texas, for example, private health insurance of abortion is banned except in limited circumstances. In Missouri, a healthcare provider must prove that an abortion met the criteria for the very limited legal exceptions for performing the procedure. In Tennessee and Alabama, for example, the state constitutions actually provide that citizens do not have the constitutional right to an abortion in the state. Almost as restrictive are states such as Arizona and Georgia. Though not complete bans, Georgia bans abortions at 6 weeks and later, and Arizona bans abortions at 15 weeks or later. North Carolina is slightly less restrictive, as it has an abortion ban at 20 weeks or later. Many of the states that have extremely restrictive laws on abortion access also require counseling prior to an abortion procedure, and some states even have up to a 72-hour waiting period after the mandatory counseling to receive the procedure. On the flip side, certain states such as Illinois, New Mexico, Colorado, Minnesota, New York, California, and others are currently enforcing abortion access protections. For example, in Illinois, qualified healthcare professionals and not just physicians can provide abortions. Also, private health insurance plans must cover abortion procedures, and state Medicaid funds also cover abortion. In Oregon, New Mexico, and New Jersey, abortion is actually not restricted based on gestational age whatsoever. All of this being said, the overturning of Roe v. Wade has clearly created a deeper divide on abortion access and extreme disproportionate access across the country. States with easier access to abortions are now experiencing much longer wait times for these procedures. This is resulting in certain states becoming quote-unquote destinations for abortions, especially those states with easier access to abortions that geographically border states with bans or extreme restrictions on abortions, such as states like Illinois and New Mexico. As you'll see on the image in the PowerPoint on your screen, the Guttmacher Institute has a helpful map that you could click on and check out the laws in the various states across the country. I find the color coding very helpful. Again, the impact that Dobbs has on this interstate travel for abortion procedures is significant. The right to interstate travel to receive abortions in states where it is legal was not contemplated in Dobbs, and per Justice Kavanaugh's concurrence was not up for debate. However, we are sure to see new state laws in the near future that test the boundaries of our constitutional right to interstate travel. For example, a new law in Idaho was recently signed into law earlier this month and provides that an individual will suffer criminal liability if they help transport a minor to receive an abortion without parental consent, therefore limiting that individual's right to interstate travel to receive medical care. This is the first of what may be many types of abortion-related laws restricting out-of-state abortion care access. Violators of the new Idaho law could face years in prison, as well as face civil liability by the child's parent or guardian. States with quote-unquote trigger bans that ban abortions altogether have laws that penalize individuals who perform or seek an abortion with civil and criminal penalties. In many states, this can include jail time. So jumping back to this image on your screen, the 7, just in case it's too small to see, the 7 policy categories from the Guttmacher Institute include extremely restrictive, which means the state bans abortion completely; very restrictive, meaning the state has multiple restrictions and early gestational age ban; restrictive, which means the state has multiple restrictions and later gestational age ban; some restrictions and protections, meaning the state either has a few restrictions or protections or has a combination of restrictive and protective policies; protective, which means the state has some protective policies; very protective, meaning the state has most protective policies; and most protective, meaning the state has all or almost all of the protective policies in support of abortions. Now, some of you may be wondering, what does this have to do with me as an employer? The implication of the varying state abortion laws on employers is complex. With laws that may criminalize the aiding and abetting of abortions, the question becomes whether an employer would be aiding and abetting an abortion in a state where it is illegal if it provides the tools, resources, benefits, or leave time for an employee to access the procedure in a state where it is legal. Last year, Texas legislators went so far as to propose a bar on companies from conducting business in the state if the company pays for employee-related abortion expenses. Again, although there is not yet and may never be total clarity on these issues, all we can do is speculate the potential risks and weigh them against the ultimate goal an employer may have. A significant and more clear risk to employers are these bounty hunter laws that states such as Texas are currently enforcing. The Texas bounty hunter civil statute allows any person, including a coworker, to sue another person if they believe that person aided and abetted in procuring an abortion. An employer may be considered aiding and abetting if it provides cost reimbursement for an abortion procedure. It is less clear if an employer would be aiding and abetting by providing leave time to seek out the procedure. My colleague Allyn will dive deeper into this topic later in the presentation. Again, these are not issues that have been presented to or thoroughly interpreted by the courts yet in wake of Dobbs. So these are just risks that we identify at the outset simply as a possibility. The same goes for a potential ban on medication that is used for abortions. Although the Supreme Court stayed the district court's preliminary injunction on the FDA-approved abortion medication last week, this means that it will now return to the Fifth Circuit in May and could end up making its way back to the Supreme Court down the road. If states are able to impose criminal liability on the dispensing and use of this medication, then employers with healthcare plans that cover this type of medication could face liability if they still cover the medication. Again, this is all merely observations and conjecture, as we have yet to receive finality on this particular decision. Not to mention, the widely varying state laws on abortion access, kind of goes without saying, create significant issues and questions, especially for employers who have locations and/or employees in different states. An employer with employees in both Texas and Illinois, for example, are now dealing with vastly different legal landscapes for employee access to abortion care, and in turn may have vastly different obligations as an employer in each of those states. My colleague Allyn will go into more details on how multi-state employers can deal with these varying laws and navigate this treacherous landscape. So here's our first secret word of the day. Today's first secret word is implication. Please select the word from the list below.
Hi, everybody. This is Allyn Lowell. I'm going to be talking about some federal laws that are at play here that are not specifically about abortion, but that will come into play as employers try to figure out what their obligations are and what benefits employees are entitled to. First, we're going to talk about the Pregnancy Discrimination Act. So you're probably all aware of Title VII, which prohibits discrimination in employment on the basis of race, color, religion, sex, and national origin. It's been amended a few times, including in 1978, which was to add the Pregnancy Discrimination Act. The Pregnancy Discrimination Act, as it sounds, prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions. So pregnancy discrimination itself involves treating an individual, and that includes both applicants and employees, unfavorably in any aspect of employment. So that could be hiring, firing, pay, job assignments, promotions, layoffs, fringe benefits, which would include leave and health insurance, and any other terms or conditions of employment. So some courts have looked at that phrase, related medical conditions, and held that would include abortion. Specifically, the Sixth Circuit in 1996 in a case that's called Turk v. Holland Hospitality. It affirms the EEOC's position, which was that the PDA prohibits an employer from discriminating against a female employee because she exercised her right to have an abortion. The Third Circuit later followed that same reasoning, and some other district courts have as well. But the Pregnancy Discrimination Act doesn't require employer-sponsored health insurance plans to cover the cost of abortion normally, but where the life of the mother would be endangered if the fetus was carried to term, the PDA does require employer-sponsored health insurance plans to cover that abortive or abortifacient care. So that's obviously going to be a conflicting principle in some states that have moved towards banning abortion, even in cases where the pregnancy does endanger the life of the pregnant person. Of course, more practical issue for pregnant employees in those states will be that they won't be able to find that medical care in state at all, even if the pregnancy is endangering the life of the pregnant person. But it's still worth noting that the PDA does mandate that coverage in employment-sponsored health insurance plans, regardless of what the state law is there. Sorry, I missed that slide. Okay. So next, talk about the FMLA. That's another federal statute that comes into play when we're talking about these issues. So the Family Medical Leave Act entitles eligible employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. So in short, the eligible employee gets to take leave, gets to come back to their job just as it was when they left without any changes in the terms and conditions. Eligible employees can take up to 12 weeks of leave in a 12-month period. That can be following the birth of the child. It could be after adopting or taking in a child for foster care. It can be to care for a spouse, child, or parent who has a serious health condition. Or it can be for the employee's own serious health condition, something that makes the employee unable to perform the essential functions of his or her position. Covered employees are those that have 50 or more employees within a 75-mile radius. So obviously the FMLA it doesn't apply to very small employers, and it doesn't even apply in smaller work sites of large employers if there aren't a sufficient number of employees at those work sites. Eligible employees are those who have worked for that employer for at least 12 months, and in the preceding 12 months, so the 12 months before the request for leave, they've worked at least 1,250 hours. Eligible employees can get this leave under the FMLA if their healthcare provider provides a valid certification of a serious health condition. So in terms of what we're talking about here with abortion care, I think it's obvious that we can think of times when a pregnant person's health is endangered, maybe their life is endangered because of a pregnancy, an emergency abortifacient care is needed. Those sorts of situations, I think, are clearly going to be seen as a serious health condition that would entitle an eligible employee to leave under FMLA. What is less clear is whether elective abortions, where there's an absence of any other symptom or condition that's affecting the pregnant person, in those elective abortions, are those serious health conditions. We'll discuss it more in a few minutes, but employers in states that prohibit elective abortions may be concerned about their own liability if they do grant leave for elective abortions. So for instance, states like Texas, that's where I'm located, I'm in the Dallas office, there are laws here that prohibit, quote, furnishing the means, end quote, for abortion, and under different statutes, aiding and abetting illegal abortion. So there's currently pending litigation to find out exactly what the scope of that liability is, what sort of action could actually could lead to liability either criminally or civilly under those statutes. But there is concern that something like granting leave, even under the FMLA, by considering something like abortion care to be a serious medical condition, does that equate to actually furnishing the means for an abortion? But as I mentioned, we'll come back to that in just a minute. So next we'll talk about the ADA, that's the Americans with Disabilities Act. That act prevents discrimination based on a person's disability. And to comply with the ADA, an employer must engage in an interactive process with an employee with a known disability. So the employee doesn't have to come to the employer and tell them that they have a disability for the employer to be compelled to engage in this interactive process if the employer is aware of the disability and more importantly, the impairments from the disability and the ways that disability affects the employee's ability to do their job. Then the employer needs to engage in the interactive process. So the interactive process is just an informal, ongoing conversation between the employee who requested accommodation or that the employer realizes needs accommodation and the employer itself. So that can be an ongoing conversation trying to find accommodations that will both work for the employee to be able to perform the essential functions of their job while not posing an undue burden to the employer. So under the ADA, pregnancy itself is not a disability, but the ADA does prohibit discrimination for pregnancy-related conditions. So employers have to accommodate pregnancy-related restrictions just as they would non-pregnancy-related restrictions. What is unclear at this point is whether abortion or abortion care is a pregnancy-related restriction under the ADA that would need to be accommodated. Okay, now we'll look at the second secret word for the day. Today's second secret word is discrimination. Hopefully you've had an opportunity to select that word, discrimination, from the list. We'll move on. Okay, so we'll talk about potential employer liability here. As we've already talked about and we've seen, there's this patchwork of different state laws either protecting access to or prohibiting abortion across the country. And the degree to which they either protect or prohibit abortion varies greatly. So obviously also the kind of liability, if any, that an employer may face about their policies and benefits in relation to abortion will vary based on state. We can't go through all of them, of course. So I think to use sort of a worst case scenario of possible liability that an employer could incur, I'm going to use Texas as an example. Texas has its own patchwork of anti-abortion laws that it's enacted over really a century. And while there's still confusion and litigation about which laws are applicable and to what extent, the threat of liability is still a very real and present one. As Zoe alluded to earlier, some state legislators have openly threatened Texas employers about liability, both criminal and civil, for providing abortion-related benefits to Texas employees. Texas legislators sent a letter to the chair of global law firm Sidley Austin threatening criminal prosecution and civil liability after Sidley Austin announced it would cover the cost of abortions and travel care for its Texas employees. And notably, many other particularly large employers have made similar pronouncements and have been targeted by some Texas legislators with threats for those as well. So there are a few different laws here at play in Texas. The first is a set of criminal laws prohibiting abortion that were enacted in the early 20th century, and those were the ones that were actually at issue in Roe. So the Supreme Court in Roe struck down that law as unconstitutional and held that there was this privacy right, this constitutional right to privacy in abortion, so that abortion was a constitutional right. With Dobbs, which overturned Roe, some people in Texas have taken the view that those old laws that were struck down in Roe are resurrected again, and they're once again applicable just as they were before. That's important because one of those laws is the one that I mentioned earlier, where there's a prohibition against, quote, furnishing the means, and quote, for another to obtain an abortion. I think the common understanding of what we would think about for furnishing the means would be to supply instrumentality to actually perform an abortion, or these days when medication abortion accounts for so many abortions, to supply the medication. But there remains a possibility that zealous DAs could interpret the provision of a leave of absence or giving financial support, say travel reimbursement, or employee to travel out of state for an abortion to be furnishing the means under that statute. So also at play in Texas, which Zoe also mentioned, and this is similarly in other states, is a trigger ban. So that was a law that was enacted before Dobbs, but in anticipation of Roe being overturned. So it was in Texas and trigger bans elsewhere. They're designed to be triggered to go into effect at such a time after the Supreme Court overturned Roe, which of course last summer it did in Dobbs. But the Texas trigger ban prohibits abortion unless the pregnant person risks death or substantial impairment of a major bodily function. A violation of that law is subject to first-degree felony. So in addition to criminal prohibitions on abortion, Texas also famously has a C8, that's one of those bounty hunter laws, that bans abortion after the way that it terms it is the detection of a heartbeat at around 6 weeks. I won't get into whether or not that's medically accurate, but that's the way the law is written. In any case, that act imposes civil liability, and it's quite significant monetary liability on anyone who knowingly aids or abets an illegal abortion. And that would include paying for or reimbursing the costs through insurance or otherwise. And claims under that act can be brought by any private citizen against any other private citizen that they believe aided or abetted an illegal abortion. Now, of course, abortions that are performed elsewhere in states where they're legal are not illegal abortions. There is some issue there about medication abortion and whether or not both pills are taken elsewhere, or if, say, the first pill is taken in another state where abortion is legal, and then the second pill is brought back to Texas and taken here, then it is transformed into an illegal abortion. I think what employers need to be thinking about in terms of bounty hunter laws like this is how that could affect sort of collegiality and just their workplace generally. If you've got different employees who are aware of each other's health status, say they're aware that somebody else was pregnant, and now that know that person is no longer pregnant, do they bring something against their coworker or somebody who they know to be close to that person, saying that they aided and abetted and having that person end their pregnancy? So there's just a lot there in terms of workplace culture to be be considerate of, and to really reinforce policies that have people maintaining professional boundaries at work, so that you don't have these sorts of issues and you don't have all the kinds of issues with discovery that come with these claims. We'll come back to this mention on this slide here about D&O insurance. That is something that is a good precaution for civil liability. Of course, it won't do anything for criminal liability, but it is a good precaution. Okay. In talking about in the wake of Dobbs, so many employers that have employees in different states, including in states with restrictive abortion bans, have started considering how to support those employees, particularly so that they would have equal access to the same reproductive health care as the employees in less restrictive states have access to. So an important place for any employer to begin is to review their health plans and consider whether and how much they want to pay for employees to travel for out-of-state abortions. And if they do want to pay something, and whatever that amount may be, how do they want to frame that support? Because there's a few different ways to go about this. So it's important to recognize the applicable laws, how that could affect the changes that employers want to make. Self-funded employers are going to have more flexibility to make plan design decisions because they're not subject to state insurance laws. So employers who are not self-funded, on the other hand, that is, they have insured plans, they have less flexibility because insured plans are subject to state insurance laws. And in states prohibiting abortion, there often already are or are being considered insurance laws prohibiting coverage of abortion. Regardless of those state laws, just as we discussed earlier, under the PDA, all plan sponsors still need to cover abortions in the case of medical complications or when the life of the pregnant person is threatened. So most health insurance plans are also going to be subject to the Employee Retirement Income Security Act, ERISA. ERISA does not restrict employers from covering abortion benefits. That includes reimbursing travel costs for out-of-state abortions. But it also does not require employers to cover abortion benefits. So again, nothing in ERISA changes the directive under the PDA to cover abortion when the life of the mother is endangered. ERISA preempts state laws relating to employee benefit plans. So in states with insurance laws that restrict employment benefit plans about covering abortion, ERISA preempts those state laws. It does not preempt state criminal laws. So this is significant where there are criminal laws, like we discussed here in Texas, that have been threatened against employers who provide abortion benefits. So some things that employers are considering in providing abortion services or supporting access to abortion services in states that prohibit abortion. One thing to consider is adding or expanding to medical travel reimbursement benefits. So employers who want to add travel benefits for abortion, for example, they should also consider the Mental Health Parity and Addiction Equity Act. So that's an act that requires that restrictions on mental health and substance use disorder benefits to be no less stringent than restrictions on medical and surgical benefits. So to comply with that act, employers might want to consider expanding medical travel benefits to also include mental health benefits that are subject to state bans, and that would include things like gender dysphoria treatment, which in some states has been prohibited, at least in part. Things like puberty blocker drugs in minor children. So to make sure that they're complying with the Mental Health Parity and Addiction Equity Act, and they want to consider broadening the travel reimbursement so that it's not just about abortion care. And another good reason to do that is just the neutrality of that kind of policy language. So a good broad option is to reimburse travel and lodging for any service or treatment covered by the plan if there isn't a network provider available within a 50 or 100-mile radius. So in a place like where I am in Dallas, there's not going to be a network provider for abortion or likewise probably for some gender dysphoria treatment within 50 or 100 miles because it's, abortion is prohibited here. So the neutrality of a language that covers any service or treatment that's not available within 50 miles, within 100 miles, whatever the scope needs to be. It also reduces the risk that a state like Texas can prosecute the employer for furnishing the means or for aiding and abetting because the policy isn't spatially related to abortion. It applies broadly. So there are a few different ways that employers can offer reimbursement benefits if that's what they want to do. And a program established by an employer to reimburse medical expenses would generally be a group health plan, so that will subject it to ERISA. It's kind of difficult to create something like this, a medical reimbursement that's just a one-off and it's not actually a plan under ERISA. It'll also be subject to other laws. There's HIPAA, Affordable Care Act, COBRA. So these are all things that employers need to consider when pulling together these kinds of benefits, and they need to work with their current service providers in doing that. So that's third-party administrators, pharmacy benefit managers, payroll and tax providers. Those are all different entities that can be helpful to see what kind of abortion benefit designs they can work with. I know that there are a couple of larger employers out there that have already published guidance on abortion and abortion travel expense coverage. United Healthcare and Blue Cross Blue Shield have both done that, but not all insurers or third-party administrators are going to be able to accommodate benefits. So employers will want to review their existing policies and look at what other policies they may want to add. So in the cases I'd mentioned earlier, the director and officer coverage, that might be something that if employers don't already have that and they're operating in states like Texas and want to offer any kind of abortion access benefits, they may want to also make sure that they've got that director and officer liability insurance as well as ERISA fiduciary liability insurance. So those policies aren't going to protect from criminal prosecution since ERISA doesn't preempt state criminal law, but they will at least provide some protection from the amount of civil risk that the employer is taking on. There are also some issues here with the tax treatment for medical travel reimbursements. Adding that kind of a benefit can also subject an employer to additional federal tax reporting and withholding obligations. There are some kinds of travel costs that have to be treated as a medical care expense if it's for the primary purpose of obtaining the medical care. So employer reimbursement policies should be drafted very carefully to limit reimbursement of travel necessary for medical care because reimbursable expenses include transportation expenses up to $50 a night of lodging or hotel expenses and other transportation and lodging expenses that could be for a travel companion if that travel companion is necessary for the patient to obtain medical care. So all of that to say, without getting too much into the weeds of the Internal Revenue Code, that it is an issue to be considered when employers are trying to draft policies that could support employees and their access to abortion care in states where it's not allowed. Okay. And at this point, I will turn it back over to Zoe to talk about some practical issues in the workplace.
Thanks, Allyn. Yeah, I think we can all agree we're at a kind of a new point in society where talking about things like abortion are a little more commonplace than they used to be in light of the political landscape in the last few years. So because of that, abortion and reproductive justice are subjects that coworkers will certainly have different opinions about. Employers should be careful not to let discussions about such topics derail productive workplace camaraderie. So employers should be sensitive and mindful that these discussions are likely taking place between employees already, and remind employees of their obligation to maintain civility and abide by workplace policies and appropriate workplace conduct. Employers should be prepared for potential right to choose versus right to life conflicts in the workplace, especially for employers in states where trigger bans are already in effect. Human resources and other EEO professionals should discuss action plans for addressing those types of disputes in the workplace. Such sensitive topics, especially if the employer implements additional benefits for employees to seek abortion care, whether more generally, as Allyn just spoke upon, or specifically, could lead to employee unrest and just general disagreement among the general employee population. Employers should be prepared to step in and mediate and counsel employees on their concerns and conflicts so as to prevent harassment of employees who share different views from one another. And this is something to keep in mind, of course. As we all know, the political landscape the last few years, we've seen more and more cases of just polarization of political opinions and that trickling into the workplace. So this is no different. This is just one branch of how the political landscape could trickle into the workplace. And what employers don't want to do is encourage these sensitive topics to be talked about in the workplace. And if they are, to make sure that human resources and management are prepared and trained on how to redirect conversations, appropriately adjust conversations, and prevent harassment of employees with differing opinions. So of course, employees must continue to abide by their employer's code of conduct and handbook regarding appropriate workplace behavior. And as always, employers must ensure that all employees continue to be treated equally, regardless of their opinion and political views. Workplace policies must be applied and enforced equally to all employees. Employers also must make sure that they are providing consistent health care to each and every employee. In other words, what we should not be seeing are one-off leave opportunities for someone seeking an abortion and not having one-off leave opportunities for anyone else. So I think consistent, streamlined healthcare policies and leave policies for each and every employee is key. In light of these sensitive and important topics playing out in real time, it would be prudent for employers to put together a refresher course for managers in HR on sensitivity training and appropriate workplace conversations. It would be helpful for employees to receive a reminder on how their obligations under the applicable code of conduct or workplace policy, or collective bargaining agreement for that matter, are implicated by discussions on these topics, and how any such workplace discussion on these topics can lead to unrest. The unsettled landscape of these legal issues are only just getting started. As daunting and frankly chaotic as it may seem right now, it does not appear that employers will receive clarity on their obligations and restrictions in terms of abortion access for employees and employer liability anytime soon. All we can do in the meantime is ensure that our employees are safe, maintaining civility in the workplace with regard to these topics, and upholding the standards of the employer code of conduct and workplace policies. Again, doing some type of refresher course doesn't have to be specific to abortions, of course, but just a reminder on political discussions in the workplace, policy discussions in the workplace, the do's and the don'ts of the sensitive topics that should be broached in the workplace, and how to prevent harassment for those who feel strongly one way or the other and disagree and create unrest if you will, in the workplace. So Allyn's going to touch upon a few last topics here, specifically on accommodations and reporting.
Okay, thanks, Zoe. Right, so I mentioned previously when we were talking about the ADA that there is this obligation on employers to accommodate people that have disabilities that affect their ability to perform the essential functions of their jobs. And I mentioned that it's not incumbent on the employee to assert that need. If it's obvious to the employer, the employer has an obligation to begin that interactive process with the employee to see how they can accommodate them. And now that said, pregnant people on their own don't necessarily need accommodation. It would probably subject an employer to a Pregnancy Discrimination Act claim if they were to seek out the pregnant people in the workplace and see how they can accommodate them when those people are doing their jobs just fine without any sort of accommodation. It looks like they're being singled out or treated as though they are disabled, even if they are not. Another good reason not to do that is that there is such a thing as HIPAA, and employers need to be careful not to get too much into the medical lives of their employees. And so, as little as is necessary to know about employees' impairments is probably prudent, especially in the realm of pregnancy and abortion, possible loss of pregnancy. If an employer were to find out that somebody in their workplace had lost a pregnancy, certainly in a place like Texas, you wouldn't want to have any more conversation about that. You wouldn't want to know exactly how, because that could subject the employer to liability if they had, say, given leave for the person to go, in the pregnancy or what have you. This is the topics that we've already touched on earlier. All of that said, you don't want to make your workplace an environment where people don't feel like they can, ask for accommodations when they do need them. So I think it's always a good idea to have a refresher, once a year, once every couple of years, just about those processes and how employees can seek out HR if they're having issues doing their jobs or if they, need any kind of accommodations. There's one other topic that is not actually linked to this, but I did want to mention it just as a practical concern and in thinking about what employers want to do with their policies. And this came up at a conference where I was speaking with some in-house counsel who were talking about just the practical effect of offering abortion access services for employees and how that affects their recruiting and their ability to say move employees between states. If they will open a new office in Texas, will there be employees who are unwilling to transfer there because of their concerns about the legal landscape of that state? Presumably it works the other way as well. There could be people who have religious reasons or other reasons that they don't believe in abortion and they don't want to work for an employer that provides those benefits, but those are values that companies need to think through themselves and think about how it will affect their recruiting and how it affects morale for current employees, and take all of those things into effect when developing their plans and deciding whether or not to add additional benefits for employees who are in restrictive states. With all of that said, I will see if we have any questions. Okay, let's see. We've got one. Small employer under 300 employees in 20 states. Let's see. We're a small employer under 300 employees in 20 states. Some directly opposing laws on this. Any specific recommendations? I mean, that's obviously tricky because you've got a whole lot of different schemes to deal with there. I think that the safest way to go, if you want to offer some kind of travel benefit for people who are in states where they can't access abortion, would be to do what we talked about earlier, that neutral policy that says that anybody who needs a service that's covered by the plan and can't get that service within 50 miles, 100 miles, whatever it is, then their travel to another place where they can get that care is covered. So that way it can apply to all employees throughout the company, throughout all of those states. They all have equal ability to use that plan and to use those benefits, because it could be lots of other things. I mean, there could be cancer care, there could be other kinds of medical care that people can't access within 50 miles. And so those kinds of policies would help all of the employees, and it doesn't subject the employer to any risk in states like Texas, where a facially abortion supportive plan could subject the employer to liability. Let's see, we've got another question. Has the federal government enacted any formal policies for their employers? I'm not sure. I assume that means for employees. And I think that's, Zoe, are you aware of that? I think there's some different guidance for different agencies.
Yeah, I think with federal employees it varies. Again, that's not even to say that agencies have really put out formal guidance. Allyn, I don't know if you've seen formal guidance.
No, I feel like I have, but I can't recall what it was off the top of my head. Let's look through the next one. I've been asked if there have been any EEO complaints filed against these companies trying to navigate these laws. So far in Texas, what I'm aware of is just the threats. Now, I know that there was also a threatened EEO, or there was a sort of an odd EEOC issue that was against Dick's Sporting Goods, and that was it wasn't actually a charge. It was more of a request for an investigation into Dick's Sporting Goods because of its announced plan to provide travel reimbursement for employees who needed to go out of state to obtain abortions, and that hasn't actually gone anywhere. But the basis of that claim was that, or the asserted basis was that there was discrimination against pregnant people who chose to keep their pregnancies because they weren't getting those same benefits as people who decided, who needed to take that benefit so that they could go out of state and obtain abortions. So far, that hasn't really gone anywhere, and I don't expect that it will. But that it does sort of clue us into one of the arguments that could be made down the road.
So I see a question on whether there are any best practices for how employers should address questions on this topic. And I guess I would start by saying the number one thing would be for any type of response on this topic by an employer to an employee to be consistent. So I think if an employer is going to make changes to, or opt to make changes to any sort of policy as a result of the Dobbs decision and its impact, I think that the employer should figure that out first before they are providing any type of insight or frankly responses to questions on the topic if they don't have an answer yet. So of course, it could be the type of response that we're considering making changes, or we're considering policy updates, and we will keep our employees updated. We're researching best practices, but until that decision is made, I think it could create confusion perhaps with employees until there is a decision on any sort of action, if any, that an employer is going to make. So best practices for how employers should address questions, I would say that's number one. Number two, back to what I was saying about like water cooler talk, I think in terms of addressing questions from managers or HR on how they can appropriately step in and try to redirect any political conversations going on in the workplace that are taking it one step too far, of just making other people feel uncomfortable if they have different opinions. As I said, I think it's a little tricky now because these sort of topics are becoming way more commonplace in everyday life than they used to be, based on the Dobbs decision and the political landscape in the last few years. So I think that, with employment being such a big part of all of our lives, these topics just naturally do trickle into the workplace sometimes, and it's a matter of controlling the discourse and civility in the workplace and making sure it doesn't kind of cross a line to make employees uncomfortable. And by doing that, again, I think best practice is doing a refresher course with HR and management on how to appropriately address political conversations in the workplace, sensitive conversations in the workplace, and how to appropriately address requests for accommodations. So let me see. I think there is another question.
Okay, we've got one about a Texas employer. Okay, so the question is, how does a Texas employer deal with Texas laws that penalize employers for allowing employees to have time off to obtain procedures out of state? So that's the first prong of it. So again, it's not necessarily that allowing employees to have time off to obtain procedures out of state, that itself would subject a Texas employer to a penalty. It's if it is tied to seeking abortion care somewhere else. And again, this is not something that we have seen actually litigated yet. It is just a threat. But the threat that I was alluding to was really if leave itself is a benefit, if it is something, a benefit to the employee, and if it is for the specific purpose of leaving the state to obtain abortion care, that's where it could get tricky. I think if you've got the neutral policies where time off is granted just to obtain medical care out of state, then you don't have that issue at all. So you just have facially neutral policies. And that does mean that other people other than those who are seeking abortion care will have the benefit of it. But I think the benefit outweighs the risk there of having something that's more closely tied to just obtaining abortion care out of state. She also asked, what impact does the CBA, so a collective bargaining agreement, have on these obligations, and does Texas law impair the obligations of contracts when the CBA allows for such out-of-state procedure? Okay, so I'll take the second part of that first. So Texas law is not going to. So again, if the leave that is set forth in the CBA is facially neutral, then you don't have an issue with Texas law. And now a CBA can't give somebody in a state a right to something within the state that they don't otherwise have a right to, right? So I mean, a CBA in Texas can't give the union members the right to obtain abortion in Texas because that's illegal in Texas. So that would invalidate the CBA if you've got provisions, or it would at least invalidate that portion that has an illegal benefit in it. But otherwise, I think these are going to be things that will continue to be negotiated in CBAs because more and more union members in different states are not going to be able to obtain abortions, and so there will be, I'm sure, negotiating to have other kinds of benefits so that they can have equal reproductive rights as others who are situated in other states. The primary thing that's going to protect any of these employees is still going to be that federal law that we talked about earlier, like the PDA. ERISA can protect existing benefits in self-funded ERISA plans, and FMLA will help if pregnancy is a serious health condition. But again, I don't think that there is just blatantly an issue between the CBA, Texas CBA, and Texas law. It's just about how those kinds of benefits are couched, whether it's as a facially neutral policy, or if it's something more closely tied to abortion, then the bringing in abortion could invalidate that portion. Is there a fear that employers will need to start reporting employee pregnancies, especially for employers that receive funds from the federal or state government? But I mean, I haven't seen this yet. I don't know, Zoe, if you want to chime in on this. I know that a lot of people themselves have fears about having to report pregnancies, but my standard advice would be not to, as an employer, not to go try to find out more about employees than you need to, particularly about pregnancies or what have you. But I don't know if you've got any different thoughts on that, Zoe.
It's an interesting question. I honestly have not looked into it, but I do think it's an interesting question. I don't think it's completely out of the realm of possibility that there would be a fear of this. I don't know if that fear would become reality, but I think it is a concern that employers may have, that maybe not reporting pregnancies to go that far, but to perhaps be liable for taking certain steps with regard to state laws on abortion access. So to be determined, I guess. But I think that is it for today. Our time is up. So thank you so much for participating in the webinar. Please complete and submit the survey that we'll display at the conclusion. Have a great day, guys.
Thank you. Bye-bye.